I've just had a discussion with an exchange of views with a number of LegCo members. The discussion is on two main issues. The first issue is the way we dealt with the case of Cheung Jin-Hwa. And the second broad issue concerns looking ahead, the review and reform of the law and procedure for enhancement of protection of mental incapacitated persons and vulnerable witnesses. During the period from about 2015 to 2016, over a year, we obtained 6 specialist medical reports on the conditions of the complainant. We have on 4 different occasions sought adjournment from the court. We did all this in order to assess the stage of recovery of the complainant, and also hopefully when she recovered from the issue of post-traumatic syndrome, that she can be called to be cross-examined so that the statutory requirement for the production of the video recording that she had earlier given can be satisfied. However, in the various medical assessments, the complainant was repeatedly assessed to have been suffering from post-traumatic syndrome, and she was assessed to be unfit to give evidence. A medical expert went so far as to say that by compelling the complainant to give evidence, they will have huge pressure on her, and they will have adverse effect on her chance of future recovery. Having considered carefully the views of all the experts, the prosecution came to the view that it was not possible to call the complainant as a witness. But notwithstanding this, we proceeded to consider the balance of the evidence to decide whether the evidence nonetheless supported a reasonable chance of prospect in proving any case against the defendant. Unfortunately, in our view, the remaining evidence could not satisfy that threshold. If the department were of the view that the balance of the evidence was enough to prove any case against the defendant, we surely would not have withdrawn the prosecution.